you, Mr. Sheen. Ask council in 124223 to come forward. State v. Kansas versus Darnell Coleman. Walk whenever you're ready. You may be.
May it please the court. Darnell Coleman appears through counsel Jacob Nowak of the Appellate Defender Office. At this moment, I'd ask the court if I may reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. 2017, outside of the city of Wichita, Kansas, law enforcement discovered the body of Tamsin Kaiser, who had suffered 5 fatal gunshot wounds. A jury subsequently convicted her longtime romantic partner, Darnell Coleman, of 1 count of first-degree premeditated murder. However, due to a series of prosecutorial errors, along with a failure to give a modified instruction, the concept of premeditation was diluted to the point where any distinction between premeditation and intentional murder was effectively erased. And for that reason, this court can have no faith in the verdict returned and must reverse Darnell's conviction and remand this case for a new trial. We've identified 4 variations of prosecutorial error in our brief. Here today, I intend to focus on the first 2. That being that the state eliminated the cognitive element of premeditation when it argued and advised the jury that premeditation only requires time or time to think in order to commit the act. They then used that misstatement to dilute the temporal element of premeditation and imply that premeditation could be formed instantaneously, more specifically in the time between rapid gunfire. Regarding the first variation of prosecutorial error, it's notable that the prosecution in this case did not request the Bernhardt instruction, which is the instruction that is ordinarily given when the prosecution is going to argue that premeditation was formed after the initial altercation began, but before the act was completed. Could be that they did not want to also receive the less favorable Stanley instruction, which more thoroughly explains the cognitive element of premeditation. Nonetheless, what the prosecution did in this case was, rather than request that instruction be given by the court, gave it to the jury on their own. However, they made tweaks to that instruction. They eliminated the portion of that instruction that discussed the cognitive element altogether, the portion that says premeditation is a time of reflection and deliberation. Instead, they focused heavily on the section that states that premeditation doesn't necessarily need to be planned, schemed, or contrived beforehand, but they made a tweak there too. They added a residual clause to that. They argued it doesn't require a plan, it doesn't have to be schemed, contrived, or anything else beforehand. And that residual clause is qualified by the list of terms that came before it. Those are all cognitive elements. Those are considerations, a plan, a scheme, something being contrived. And that particular interpretation is also bolstered by what came afterwards. The prosecution then almost immediately tells the jury that there is only one element of premeditation, that is time, or time to think. They say it only requires time to have thought the matter over beforehand. That's it. Time is what it takes for premeditation. Time to think it over. Those are my words in layman's terms. That's the only requirement for premeditation, ladies and gentlemen. But it's not. That goes directly against what this court said in Stanley, where this court went to great lengths to explain that premeditation requires both a temporal element and a cognitive element. More specifically, the cognitive element being that a person has to engage in thoughtful, conscious reflection and pondering. They have to have a cognitive break that is sufficient enough for them to change a prior impulsive action. Based upon that, court has directed that anytime the Bernhardt instruction is given, the court should also then give the Stanley instruction, which is premeditation requires more than a mere impulse, aim, purpose, or objective. It requires a period, however brief, of thoughtful, conscious reflection and pondering done before the final act of killing that is sufficient to allow the actor to change his mind and abandon his or her previous impulsive intention. That's eliminated entirely when we tell the jury that the only element of premeditation is time to think. And that's not just an important element of premeditation. Based upon the language in Stanley, that would appear to be the critical element of premeditation. This court said the act of overriding an internal cognitive break, that is choosing the intended act after reflection, that's the factual element that makes the crime of premeditation worse than intentional murder. That's what we rely on as a society to increase the penalty of these two crimes. And so,
How do we take those comments and consider your argument in the context of what else was said right around that statement, which was almost immediately followed by a discussion of there was time to think about it while he drove out there. There was time to think about it when he decided to pull the gun, bring the gun out, to walk around the car, all those steps that were immediately discussed following that statement about, or any similar consideration.
they also discussed the time that it would take a gun to revolve.
But I think it starts, but there was time to think it over while he drives.
I understand.
There was time to think it over when he went to the house the second time. So those next statements really do bring the contemplative part of it back into the.
They don't, Your Honor, because there is a critical distinction between time to think about something and premeditation. In other words, just because someone has the opportunity to act does not necessarily mean they're going to exercise that opportunity. Just because you have time to think doesn't mean that you are going to actually consciously reflect and ponder upon that decision to a degree that is going to allow you to abandon any prior impulse that you had. That is a critical element the jury needs to find, and these statements take it away from them. If it is just time to think, that's simply the temporal element of premeditation.
But doesn't he get to the point where it is, we take the gun, we fire multiple shots to make sure that person does die. Isn't that part, looking at the factors we can generally consider for, excuse me, for premeditation? He kind of walks through those factors in that way, again, as part of that conclusion.
Well, they start to walk through some of those factors. The walking around the vehicle, I believe, is the inference that the prosecutor wanted the jury to draw. And I understand that you can discuss the nature of the weapon used as a factor, but there is a fine dispositive line here. You can argue that someone may have predetermined that they were going to fire a gun 5 times, and that we can look at that predetermination as evidence that they consciously reflected or pondered upon the decision. What you can't do when you cross that line is when you start arguing that premeditation could have been formed in between rapid gunfire, that it wasn't formed previously, but it could have been formed after the gun started firing. And really, the prosecution in this case took it a step further than arguing that it could have been formed afterwards. They say there was time to think before the first shot, after the first shot, after the second shot, after the third shot, after the fourth shot. I want her to die. That's premeditation, ladies and gentlemen. That is a declarative statement. That is the prosecution arguing to the jury that the fact that Tamsin was shot 5 times is conclusive of premeditation, that they don't need to consider whether or not he actually exercised that opportunity to think as he's walking around the car, if that is really what happened, because we don't know. That we don't need to consider whether or not he had formed this before they drove out there, or if it happened in the heat of a passion from a discussion that occurred based upon an ongoing argument regarding infidelity. You can just determine identity, and then we're done here, because the fact that this person was shot 5 times, that's premeditation, ladies and gentlemen. That's what the prosecution said. That goes against Hall.
As to that statement, isn't this case kind of in the middle of a spectrum of where we have the cases where there was evidence that the shots definitely were fired in rapid succession? People heard the shots there. And then we have cases where people heard the shots and there were gaps of time. And then we have this case where we really don't have, you can maybe draw some inferences from the pattern of the stippling, but That's about it. We don't really have almost anything even beyond that that we can infer how quickly this happened. Those 5 shots were taken.
Right.
What do we do? I mean, is a permissible argument then in that situation to have let the jury think there was more time perhaps than there?
No, absolutely not. Under that scenario, we win. This is error. We have the scenario where we know for certain that it was rapid gunfire. We have the scenario where we know for certain there was a meritorious pause. And we've made our argument in this case in our briefing that it was rapid gunfire, and we'll stand by that. But to the extent this court looks at the facts and ultimately determines, man, we don't know which one it is, then it's an impermissible argument. And the reason for that is because the state bears the burden to prove each and every element of this offense. And included within that is that the applicable period of thought is long enough to actually form the concept of premeditation. And I understand that that period is ordinarily very brief. The 2 periods of time that this court has said is not long enough is the time it takes to pull the trigger and the time it takes in between gunfire without a meritorious pause. We can't shift that burden onto the defendant to prove that there was no meritorious pause. The state has to first present evidence that there was, like was the case in State v. Brownlee. That does not happen here. In fact, I don't even think the state makes an effort to do that. If we look at what they said, particularly the second prosecutor said, he's talking about the revolution of the cylinder of the gun. He says there's a moment there. We assume someone would have a reaction. They're talking about the time in between, a very brief period of time. The time it takes for the gun to manually reload or ready the next round of ammunition.
Mr. Nowak, let's say that we're convinced, that contrary to the chief saying that the prosecutor walked through the factors, think before he drives, thinks before he goes to the house the second time as he walks around the vehicle. I think that your opening statements demonstrate that there is kind of a confluence of your first and second points of error, prosecutorial error, and then the premeditation instructions. So my question is, first, as though, because they're kind of together, at least in the sense of if we find that there's prosecutorial error, then the question becomes whether or not the verdict would have been different, right? Or not whether the
For clear error or for constitutional harmless error? The prosecutorial error on its own would be constitutional harmless error beyond a reasonable doubt.
right. Okay, so we get to that, and then we have to automatically take into account the jury instructions, right?
Well, that would be our position. And before,
And so my question is, so the jury instructions as they were given, were they legally and factually correct?
Chief Justice, before I answer that question, I see my. Sort of. The jury instructions that were given were legally and factually correct under ordinary circumstances. However, once the state brings in the temporal considerations, once they argued that this premeditation could have been formed after the initial altercation, which in this case would have been the first gunshot that was fired, that brings in to question whether or not the jury could have been confused by that. It's our position that that was a confusing argument that would have benefited from both the Stanley and Bernhardt instruction being given. The court could have mitigated the prosecutorial errors that occurred in this case. And then for that reason, pick as it on its own was not factually appropriate in this case. They needed to give the modified instruction.
Does the jury instruction claim then hinge on a finding of prosecutorial error from your perspective?
It would be very difficult to succeed on the jury instruction issue on its own. I do think that that particular argument is best viewed through the lens of cumulative error because it would have mitigated the damage. The court could have set the jury back on the right track and did not. Chief Justice, if there are no further questions.
I assume that's how you would distinguish Hilliard.
Yes, that's how we would distinguish Hilliard. In Hilliard, there was not any temporal concerns. That's what this court said. And that was anytime we're going to be looking at Bernhardt or Stanley, It's going to be a fact-intensive question, case by case. Here, where the state actually made this argument, that's where it becomes appropriate, because the jury would have been confused otherwise, because the cognitive element was eliminated and the temporal element was diluted. Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Obviously, I'll focus my argument today on issue 1 and to some extent issue 2. To start with, I heard my colleague say that there were basically 4 categories of prosecutorial error claims that he's raising. And honestly, as I read through and worked on this brief, I had a hard time even counting how many different claims of prosecutorial error there were, because in many instances, they were taking one statement of the prosecutor and arguing that it violated multiple tenets of closing argument or multiple areas of law. And that leads me to my first point, which is that I think sometimes in cases like these, there is a tendency to maybe mistake quantity for quality. In other words, that because a defendant can cite 10, 12 passages and say, these are all error, there might be some tendency to think, well, this one or these 2 aren't quite as clearly wrong or not as clearly meritless as these others. So we're really going to lock in on these and think that there must be something to them. Your Honors, my position is it's entirely possible that if a defendant raises 12 claims of error, that all 12 of them are meritless. And I also feel like this is a perfect example of a case where, and I've argued in this brief and many others for numerous years, that the lack of an objection at trial should be relevant. I fully understand, and I don't even disagree with the fact that they should be able to raise claims of prosecutorial error in closing for the first time on appeal. I understand that. And I also respect the fact that as prosecutors, we do have a higher duty and that we cannot do things that are outside the boundaries of the law. I take no issue with that. But what I do think is that when there is a trial with 2 very experienced prosecutors, 2 very experienced defense attorneys, and a judge, all of whom have a duty to ensure a fair trial for the defendant, and not one of those people takes issue with a single thing that was said in closing argument. And yet on appeal, from a cold record, without being able to see the facial expressions or the tones or anything else that happens in the courtroom, we now have a situation where pretty much every single thing that the prosecutors argued in this case is being picked apart and claimed to be erroneous. When you look at the transcript, you will see numerous times that both prosecutors, both in the original closing argument and in rebuttal, they both numerous times used the word thought or thinking in discussing premeditation. That's the cognitive element that the defense is trying to claim was completely ignored by the prosecutor. The state didn't simply get up there and say time. They said time to think about the matter beforehand, time to have thought about it. I don't understand what the cognitive element is if not thought. And I think that's what this court's case law reflects. I would agree that if the prosecutors had simply gotten up there and said, we showed that there was some time, so therefore that's premeditation, then absolutely I would be in a very difficult position today. But when you look at the totality of the argument, they numerous times emphasize both the temporal and the cognitive element. The one passage in particular that the defense cites in the rebuttal closing where the prosecutor starts to say that time is the only thing, is the element, he then immediately follows up and clarifies that by saying time to think about the matter. So there's not a single passage where either prosecutor simply says that time is the only thing that matters here. They emphasize both the temporal and the cognitive. And I would disagree with the assertion that counsel made that the state's whole theory in this case was based on saying that the premeditation was formed after the first shot. Now, they clearly, in one passage, they did make the argument consistent with what was made and argued in Moore. There was an argument here that what happened after the first shot can still be considered in looking at premeditation, that that's a factor. But as Chief Justice pointed out, there were numerous times that the prosecutors here pointed to other things that happened long before the first shot as premeditation. So they talked about going back to the house a second time, driving to this remote area, stopping the vehicle, getting out of the vehicle, walking around the car, getting the victim out, getting close enough to her before firing the shots that the stippling was found on the wounds. These are all things that happened before the first shot was fired. So this was not a case at all where the prosecution was operating under the theory that he did not premeditate the first shot. And I'd also point out that unlike the cases in which, like Bernhardt, where there was this additional language that was found to be appropriate, the cases generally that approve of that language are situations where you have some evidence of an initial dispute or physical argument or some sort of an altercation. Then there's a pause, and then there's the ultimate killing that happens. There was no physical dispute between these two people. The evidence showed that there was no sign of a struggle inside the vehicle. The coroner testified that the victim had no meaningful injuries to her body other than those caused by the gunshots. So this is not something where these two people had been in a physical dispute, and then later on the defendant commits the final violent act. He drove her to this remote area and killed her in cold blood. The evidence showed that he then deleted, or he thought that he was able to delete the Facebook messages, which further showed that he was angry with her on that night. And of course, we have the testimony of one of the victim's daughters, who also indicated that she saw him when he came to the house. And much like the text messages, she saw that he was in fact angry, partially because the victim had spent time with another gentleman that evening. So this was not a case where we were arguing that, oh yeah, the first shot, he hadn't premeditated that, but after the fact he did. That was simply one element, much like in Moore, in which we were saying that in addition to all the evidence leading up to the first shot, you also have the fact that there was testimony about these additional shots. I think the coroner was the one who testified that the evidence suggested that perhaps the final couple shots were fired after the victim had already fallen to the ground. So again, much like all claims of prosecutorial error, I would just urge this court to read the closing argument in its totality, look at the context surrounding those statements, look at the fact that in the defense closing, the defense counsel was the one who, I think I cited it in my brief, I can't remember the exact number of times that he used the word or some derivative of the word planned or planning or plan. And so much of what the prosecutors were doing was simply reminding the juries, consistent with the law, that we don't have to prove that this was thought out days or hours in advance, but we just have to prove that he did have.
That's not what the prosecutor said. But I understand your argument that in context, maybe that's what the prosecutor meant. So I have read the whole prosecutor's statement as you requested and try to put it in context, but I want to ask a few questions along the lines of your argument. Because it seems to me that it's possible, at least, that someone hearing this closing argument could have taken away from it the idea that to find premeditation only requires that I find there had been sufficient time to have thought the matter over. Not that the matter was actually thought over, just that there was sufficient time to have thought it over. Is there a distinction in your mind between those two things?
If there is, it's a very fine one. I think if the prosecutor is saying that premeditation requires time to have thought the matter over beforehand, that does reflect both the temporal and cognitive elements. And then
Why does it? Why though? In other words, I can imagine a scenario where two faction scenarios that as far as the temporal aspects are identical. And in hypothetical A, the individual actually did engage in that cognitive thinking it over. And in hypothetical B, the individual did not engage in the cognitive thinking it over. Would you say they both of those are premeditation or only one?
Well, I would say that they both, I guess in the second scenario, from a factual standpoint, that would not be premeditated, but that wouldn't make the prosecutor's discussion of the elements or
Well,
the
but
legal.
but it goes to that question of, so when the prosecutor says it only requires time to have thought the matter over beforehand. That's it, time. I mean, that strikes me as at least arguably saying you don't have to find that this defendant actually thought it over beforehand. You only had to find that there was sufficient time for him to have thought it over.
And I think if the prosecutors had not taken the additional steps throughout both portions of closing to specify the evidence that we were pointing to, arguing that this defendant did in fact think it over beforehand, again, before he even took her to the scene, and then on the way there, when he got her out of the vehicle, when he approached her with the gun. So I still don't know in your scenario, even if that one passage was the only thing that we had said, I think that it would be hard for me to concede that that would be erroneous when the prosecutor there is just summarizing the legal elements.
Well, what about the fact that you pair that with the sentence above where the prosecutor is trying to rebut the defendant's argument, and the prosecutor says, premeditation does not require a plan. It doesn't have to be schemed, contrived, or anything else beforehand. Now, I understand colloquially, the prosecutor is trying to say, look, we don't have to show some sort of elaborate, we don't have to have a basement lair with yarn, establishing this grand criminal enterprise. I understand that's colloquially what's going on, but legally speaking, it does require a plan, doesn't it? It does require a scheming, a contriving, or something beforehand.
Well, and that's where I think in that first portion that you just cited from, that's where he is directly responding to the defense counsel's argument, where they had used that language.
Couldn't this be confusing to the jury, though? If you're saying it doesn't require a plan, it only requires time.
I don't think that it would be confusing in context where basically what's clear is he's saying it's not something that has to have been thought of in the manner that a lot of times jurors or lay people would think, that it has to be thought out, to use your example, in great detail for an extensive period of time here. And I can't remember specifically, I'm sure I cited in the brief whether the prosecutors had addressed that particular concept earlier in closing argument, that or perhaps even in voir dire, that you don't have to have the amount of time that a lot of jurors would typically think of.
Well, Anna, let me ask it this way. My last question. Do you think that there's a real difference in an ordinary juror's mind between thinking a matter over beforehand or making a plan or a scheme?
I think that I think the jurors would understand the distinction between, on the one hand, maybe the TV or the movie scenario where somebody does plan something out in great detail over a lengthy period of time, as opposed to somebody who maybe didn't wake up on this day intending to kill her, and maybe didn't even intend to kill her the first time that he went over to the house that evening. But at some point along the way, whether it was when he went back the second time or whether it was after he picked her up and they presumably were arguing, and he then decides, you know what? I'm going to drive her out to this remote area. I'm going to bring a gun with me. I'm going to get her out of the car and I'm going to leave her body there. I'm going to try to delete these Facebook messages. So I do think that jurors would understand the distinction between, yes, we do have to show that there was time to have thought it over beforehand, but that doesn't mean that it has to be in the detail or to the degree that you might typically associate with that, if you're just going off of the scenarios that you often see played out on TV or might even just think of in your mind. So But again, I would argue that the totality of the arguments that were made were consistent with the law. And I think this court's recognized in some of its recent case law that it is very difficult to walk this line, that some of the attempts recently to help solve some of the issues with premeditation have perhaps created other issues. And I think that certainly weighs into a question of whether the prosecutors here erred in trying to discuss this complicated concept. But again, when you look at the factual discussion that they engaged in and the totality of the remarks, I think that they walked the line appropriately. Obviously, my position is that they did not err, but shifting just briefly to that aspect of the issue and the harmlessness, there was overwhelming evidence here of premeditation. He did take her out to a remote area in the middle of the night and shoot her 5 times at close range, twice in the head, 3 times in another area of the body, all designed to be, it's not like he was shooting her in the kneecaps. He shot her in places designed to kill. He deleted those messages. And let's not forget here that, well, if you're just reading the briefs, you would think that this whole case came down to what was the exact sequence of the shots and how much time did it pass. His primary theory of defense was, I had nothing to do with this. Last time I saw her was when I dropped her off at her sister's house, and then I went to my uncle's house to get gas, and I was waiting for her to take a shower. And the next day I found out that she had been murdered. So that clearly comes into play when you're looking at whether there's a reasonable possibility here of a different verdict. So for all those reasons, our position is that the state did not err, that if you feel otherwise, that the error did not contribute to the verdict. And for those reasons, we would respectfully request that this court affirm the defendant's conviction.
Address your counsel's argument about the 1, 2, 3, 4, 5 shot. I think you fully addressed before the first shot,
Right.
but the comment about time between the second, third, et cetera.
Right. And that's where I think this case is most analogous to Moore as opposed to Hall. Hall being the case where there was evidence showing that the shots were just rapid fire. I can't remember if it was 3 or 4 shots, but there were actual witnesses who saw that. And we knew for a fact that the shots all were fired one right after another. Whereas in Moore, the prosecutors had discussed much like they did in this case, they discussed the fact that there was time after the first shot, but that was part of a broader discussion of the concept of premeditation. And essentially this court said that it's perfectly acceptable to discuss the nature of the weapon used and the number of times that it was used. So here we have a gun that was fired 5 times. And as part of a broader discussion about all of the evidence showing premeditation, the prosecutor simply pointed out that that's one additional thing that the jury could look at, is that he did fire the first shot. And, again, we said there was time that he had formed premeditation before, and then went on to say, and then after the first, after the second, after the third, after the fourth. So I think my response would be that that's very similar. I don't want to say that any 2 cases are identical, but I think that's very similar to what happened in Moore, and that this court said as part of a broader discussion about premeditation, it's appropriate to comment on the weapon used and how many times the defendant used it.
But there was evidence in Moore. What was the evidence here? I know that the prosecutor seems to have perhaps proffered his own opinion about the time it may take for with a revolver, but was there any evidence about that?
There was no direct evidence regarding how long it took. I think there was, again, the coroner indicated that there was, it was at least plausible, if not likely, that the last couple of shots were fired after the victim had already fallen to the ground and was prone.
But didn't the coroner talk about how that would have been instantaneous? I think was even a word that the coroner might have used.
I can't remember if she used that exact word, but I agreed in general that it was something where, that she said that she probably would have fallen right where she was shot. So but again, I think that, you know, there was this conflict, I guess, between the CSI's testimony where she gave her opinion as far as whether she thought the headshots or the body shots came first, but she acknowledged that that was a personal opinion more so than anything based on any science or physical evidence, whereas the coroner said, no, it's not possible to determine the sequence of the shots. So there was obviously some discussion about that. But I do think that still, it is fair for the prosecutor to, you know, based on the somewhat conflicting evidence here, I think it's fair in those situations for a prosecutor to make reasonable inferences from the evidence and to suggest that there was in fact at least some period of time that would have given him yet another opportunity after each shot to think the matter over yet again. And I think that's the context in which those remarks were made.
Well, and what are they thinking about? They're thinking about the intent to kill. And in this case, there was some pretty strong evidence of intent to kill, wasn't there?
Certainly.
So really, possibly the more difficult question is whether there was an opportunity and time to think about what he was going to do.
Right. And I think, of course, it's always, unless you have a situation where a defendant flat confesses or is heard to have said something by somebody else, it's always something that you're going to have to show circumstantially as far as what was actually in somebody's head here. But I think, again, that's where you can't divorce it from the comments about what had happened before they even got to the scene here. Because you're looking at other evidence showing that he was angry that night. They exchanged these messages. He drove her out to this remote area. He took her out there made sure that he had his gun with him. And so I think when you consider that evidence, it is a reasonable inference to make that then during the time between shots, that premeditation is something that was on his mind. Again, looking at everything in its entirety rather than just trying to parse it out. Because again, I acknowledge if this was a case where the only theory that the prosecutors presented was to say, we think that he formed premeditation after the first shot, that would make my job a lot tougher here, but that's not what we have. That's factually far from what we have in this case. And again, I just can't escape the fact that he drove her out to a remote area in the middle of the night. This isn't a situation where they were still at Shayna's apartment and they were just arguing. And all of a sudden, he happens to have a gun in the apartment and he snaps and shoots her. He took her out to an area where clearly he didn't think that anybody would see him. And perhaps unfortunately for him, he left her very close to the road and there was this surveillance footage that pinned down exactly when this happened. And we know when this happened. We know it was very shortly after he had angrily left the apartment with her. And so I think those are all of the concepts that the state was discussing in the closing arguments. And again, our position is that they did properly toe that line. I acknowledge it's a difficult one to walk, but I think they did it properly here.
Thank you, Mr. Malone.
Thank you, Your Honors.
Walk, you reserve 3 minutes.
Thank you. I'd like to briefly address the concept of whether or not we divorce the statement from other statements made by the prosecution. Largely, this case presented a theory that premeditation was formed after the initial shot was fired. There are instances where the prosecution also did give the jury appropriate considerations that they could have considered, such as driving out there. That said, immediately after telling them that premeditation was necessarily formed after the shot was fired, they told them they can disregard that they don't need to prove premeditation occurred from the moment that they left the house. They just have to prove that premeditation occurred before the killing. And since time to think is premeditation and there was time between gunfire, that was sufficient. But we do, in a sense, divorce it from the comments. I understand when look at context, we review the argument as a whole, but we're trying to determine whether or not there are alternative interpretations for it. We don't look at context and just say, well, 50% of what they said was appropriate, so we're not going to find error. We wouldn't do that if the prosecution was discussing the credibility of a witness and said, you can consider that they've been consistent. It's your determination. You can consider that they've been consistent. You can consider that they have no bias. And you can also consider the fact that I listened to what they said and I personally found them to be credible, and that should be good enough for you. We don't look at that and say 2 out of 3 ain't bad. No error, it's error. We might be able to look at it for harmlessness, but the fact that this prosecution told the jury that premeditation could be formed, was formed during the time period between these gunshots being fired, was error. Jury was unlikely to review any other theory, one, because the prosecution told them that they didn't have to, and 2, just because logically you're going to take the path of least resistance. Well, once we've determined that gunshots were fired, prosecution told us that is premeditation. Let's walk through that door. We don't need to think about what he was thinking before.
On this particular subject, I want to divorce it from prosecutor putting on personal opinion stuff, because we know that's kind of touching a third rail.
Sure.
But on this notion of how the jury is supposed to look at the evidence in order to determine whether the defendant intended. And we've got and you're saying we've got a mixed bag. So, I mean, I'm looking right now at page 13 of the transcript, and I don't see any problem with them saying, what they're telling the jury to do. And you're saying in other parts, there are misstatements maybe. Are we supposed to look at the overall theme of this? It comes to an issue like evaluating the evidence to see whether I'm getting at.
And how the jury would have evaluated the
Yeah, I mean,
evidence.
is the error here the overall, the 4 corners of the closing argument? And you look at this mixed bag of, some of it was maybe better than others, and look at the overall impact of it? Or is it enough to just have done something stupid, like say, I believed this witness? That we can put in the stupid category of prosecutor does. This is a little different, seems to me. Now, am I making any sense with what I'm doing?
I think so. Maybe you can tell me if I
Okay,
haven't
okay.
caught on. Sorry.
go ahead.
In regards to whether we look at the whole theme, I think the appropriate way to go about this is first we look at, to determine whether or not there's error, you look at the statements, then you look at the argument as a whole to review the context to make sure there wasn't another possible interpretation of that the jury might have taken. We look at the whole argument in terms of what evidence the jury could have relied on. That's when we're in reversibility. You don't necessarily need to look at the entire argument to determine an error occurred. But if the court does, and I hope it does, the entire argument's theme in this case, first and foremost, was premeditation was formed after the first shot was fired. I would direct the court to page 14 and 15 of the record, volume 15. Where they're essentially opening their discussion on premeditation, and they're going to talk about Dr. Jamie Obrist. The prosecution says, now I suspect you may hear a counter argument based on some of the questioning. Well, we don't know, but the evidence points that she was shot in the head first, and she must have died just like that. And the state can't prove premeditation because she must have died on the first shot. That was their opportunity to say, you can disregard that. We're going to prove this all happened before they got there. Not what they say. They say, don't be fooled, ladies and gentlemen. Dr. Obrist tells you you cannot determine which order of the shots was fired. They let the jury know right away. That's where they're putting their argument. After that first shot was fired, they doubled down on this impermissible theory from the jump street. There's no purpose of having, I think I had over 2 pages of discussion in my brief of them talking about the possible order these shots were fired in. And well, Dr. Jamie Oberst, she says they went in this, or we can't tell, even though Deputy Shauna Sherwood conducted a blood spatter analysis and says those two nearly instantaneously shots to the head, those were the ones that were fired first. There's no point in any of that, except to prove that Tamsin might have still been alive after the first shot, because you can't form premeditation after the victim has died. That's why that's there. Justice, I will stand for any final questions. Otherwise, I thank the court for its time.
Thank you, Mr. Miller. Thank you to both counsel for your arguments in this matter. The court will take this under advisement.